The Principal Act is amended by inserting immediately after clause 4 the following. 4A, artificial intelligence work to be protected. Works generated by an artificial intelligence system.
Immediately after clause 3.
Yeah. Immediately after clause 3, which will be 4A. And 4A is, the head note is artificial intelligence work to be protected. Works and 4A1, works to be generated by an artificial intelligence system shall be eligible for copyright protection if the works, A, has been supervised, directed, or substantially modified by a natural person, and B is original. 4A2, a developer or user who intends to develop any work using an artificial intelligence system shall, 2A, obtain the consent of the author of the work to be used in a training data set, and B, maintain publicly accessible records of the general categories and sources of content used in training data set. 4A3, a developer shall implement technical safeguards to prevent the reproduction of training data and shall provide clear usage guidelines to users to the use of artificial intelligence tools. 4A4, the minister may, by statutory instrument, A, regulate the use of copyright works in artificial intelligence systems, and B, prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. Justification, Madam Chair, to provide for works which are eligible for copyright protection and the use of copyright material in artificial intelligence systems. 2, to empower the minister to prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. I beg to move, Madam Chair.
We propose that that provision, that insertion be dropped by the House. Right Honorable Speaker, AI is a tool. It's a tool used to generate protected work. AI is not this act is not intended to regulate tools. For example, a musician uses an organ, a drum, a long drum. This act is not about the tools that you use to generate the works. This act is about the works themselves. So the AI policy is much wider, and government is currently working on AI policy on how to regulate and guide people on its use. But to say that we should attach certain value to how the copyright was made would not be appropriate. We propose that that proposed amendment be dropped.
Madam Chair, considering that you want to allow debate on this, Madam? Considering that, Madam Chair, we have made a recommendation.
Do you have any law on AI?
We have made a recommendation in our report that
no, I'm saying, do you have a law that you're referring on AI for you to borrow?
We received the
and in the circumstance that you don't have, then just concede.
Yeah, can I just make a statement and conclude, Madam Chair, and then you rule? Madam Chair, first of all, I concur with the Attorney General for now that provisions relating to AI need to be looked into further. And we made a recommendation to that effect, that government should take interest in AI matters and amend the Copyright Act further. But for now, I concede.
Next.
Clause 4(5) is amended in the paragraph B by substituting for subsection 4 the following. A contract of assignment, license, or transfer to do an act falling within a copyright shall be in writing. Justification: for completeness, to harmonize the provision with the head note by including the assignment and transfer of a contract in the proposed subsection 4. I beg to move.
Thank you.
We have no objection to that proposed amendment. The import of it is that if you want to deal with an assignment or a license of the use of any person's copyright, you can only do so by showing that you have a contract in writing. we do concede.
Thank you. I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay.
The committee proposes to insert section 13A and 13B in the Principal Act, and therefore clause 6 will be amended as follows. By substituting the proposed section 13A, the following. 13A, reversion of economic rights in copyright to author. 13A1, in a contract of assignment, license, or transfer, there is an implied term that the economic rights in a copyright shall revert to the author. A, upon termination of the contract of assignment or license or transfer. B, upon expiry of the term of the contract of assignment, license, or transfer. C, if the holder of the economic rights in the contract of assignment, license, or transfer becomes insolvent or bankrupt and can no longer meet the contractual obligations to the author. D, where the contract of assignment, license, or transfer covers the right of publication, the work goes out of print or becomes unavailable or for a reasonable time. E, 5 years before the expiry of the duration of the protection of the copyright works under this Act. Or F, for any other reason as may be prescribed by the minister by statutory instrument. 13A2, the minister may by statutory instrument prescribe the procedure of reverting the assignment, license, or transfer of copyright to the author. 13AB, in section 13B1, the proposed paragraphs A and B by deleting the word effective wherever the word appears in the provision. And in the proposed paragraph B, by inserting immediately after the word technological, wherever the word appears, the word protection. Justification, Madam Chair. The proposed 13A is replaced since the provision as proposed in the bill will frustrate freedom of contract and unlawfully deprives copyright owners the full utilization of their rights. The second justification, to adopt international best practices that allow the reversion of the rights of an author under specific circumstances. The other justification, to empower authors who have assigned their rights in a copyright works for the life of the copyright prior to the commencement of the Copyright and Neighboring Rights Act to claim back their rights 5 years before the statutory protection of the rights. And the amendment proposed in 13B are intended to delete the word effective since the word is redundant and subjective, and to insert the word protection in order to harmonize the provision with the usage of the word under the World Intellectual Property Framework. I beg to move, Madam Chair.
Honorable Speaker and honorable colleagues, the proposed replacement of clause 13A by the committee will not work in the best interest of the author. The purpose of the proposal that has been made by government is that you cannot have a copyright on any person's works for a period longer than 20 years. And that and 5 years before that, the owner of the copyright is at liberty to come and take this property back. What this clause is doing, it is mixing up the consequence of termination with the right for reversion. So what we are discussing here is the right of the author to get their works back after the 20-year, and you cannot have a copyright for, say, 40 years. It can only be a maximum of 20 years. You can write another contract. But the purpose of this was to ensure that if an author, for example, in year 1, entered into a contract for a long period, which was, say, unfair because of the bargaining power, after some time they can get benefit back of their product. We propose, Right Honourable Speaker and honourable colleagues, that this proposal be dropped and clause 6 stands as part of the bill as proposed by government. We so submit.
Sir.
And the chair of the committee. Madam Chair, you see, in the copyright law, I compose my song, And after composing my song, a certain man wants to buy my album. Remember, some time back, there was no TikTok, there was no whatever they use on social media. And this man, Kasiwukira, may he so rest in peace, bought my music. But by that time, I never had the capacity to record a video out of my music. But has the right over the song. I don't know whether Attorney General, you are following what I'm saying. Now, because it is my song, I composed it. Now, he paid me, he has been selling my music, I got my money. But now I'm composing, I'm putting in a video. I'm recording a video which I'm also going to sell. I want to say how this musician is protected under that direction. Because he's putting his music on TikTok, he's putting it on YouTube, which were not present at that particular time. But now the advantages he's using to sell and get money, which were not available by the other person who had bought the copyright by that time. Can you help me get that one, in that particular clause?
The heading of the clause, reversal of copyright to an author. So let's discuss according to that. You get it? Eh? We are looking at when do you reverse, how do you reverse. Let's be systematic. Move as per the clause. Okay?
Reversionary interests of the author are protected. And if you look at the Attorney General's contention, it does not water away that intended purpose, that the reversionary interests of the author are protected. So I concede on that.
I put a question that clause 6 stands part of the bill. Those in favor sign the contract.
It's becoming juicy now. Clause 7, Madam Chair, is amended in the following terms. Clause 7 is amended in paragraph B in the proposed paragraph 1 by inserting immediately after the word museum, the words for use by a beneficiary person other than for commercial use. Justification, the amendment will protect rights, owners' interests by limiting access to their works by beneficiary persons as required in the Marrakesh Treaty to facilitate access to published works by persons who are blind, visually impaired, or otherwise print disabled.
Right Honourable Speaker and Honourable colleagues, the import of the provision in Clause 7, amending Section 14 of the Principal Act, is discussing the fair use of works protected by copyright. The purpose of this provision is to allow the use of copyrights for educational, institutional, library, and that kind of thing, not for commercial purposes. Now, when you say for use by beneficiary person other than for commercial use, you're limiting that to only the beneficiary person. Now, that beneficiary person could only be a person who is a beneficiary through a license, through a contract, and through that kind of introduction. So, we note that we need to protect the rights of owners, and we also need to observe fair use of these products. And that is why Clause 14.2 is introduced. So we propose that the provision in Clause 7, in relation to amendment to Section 14L, be left to read, the work is used in an online learning environment by an education institution, library, archive, or museum, full stop, but not for the beneficiary person or other than for commercial use.
Chair.
Access of published works by persons who are blind, visually impaired, or otherwise print disabled. How do you protect them?
Thank you, Chair. Of course, government currently, when we are dealing with our education institution, we take into consideration all the needs of all the persons, even those ones who are visually impaired, those who are impaired in any other way are provided for. So when you say for educational purposes, it is encompassing all the person in the educational
Attorney
space.
General, K protects what he's asking about.
Fair enough. I'm
You
satisfied with
read K.
Okay,
K on the bill.
in the bill,
Yes.
does it,
It does protect.
I concede.
Okay. Avoidance of doubt, just restructure your statement, the amendment.
Right Honorable Speaker, 7 of the bill stands as it is in the bill currently, and that the proposal made by the committee should not be adopted because clause 14 properly caters for all educational purposes for which the copyright could be used. Beg to submit.
Thank you. I put a question that clause 7 stands part of the bill. Those in favor say on the contrary. Let's have it.
Clause 8.
Chair.